Hey guys, good morning. Welcome back to my channel. Welcome back to Real Talk Bougie. Guys, I have a quick update for you. Some of you will be very happy to know and to find out that Sakiyna Thompson is on her way to serving her sentence and paying her debt to society for the heinous crime committed at the Tamarack Village Apartments. Sakiyna, as we know, was sentenced on December 1st, which was last week. Well, ma'am is at the reception center. As you can see, she has been received at the reception center, and her release date is never. Current facility is the Florida Women's Reception Center, and it is showing life sentence. And let's go ahead and click. No new photo yet. She just got there yesterday. One of you guys alerted me in the DMs and said, "Fran, go take a look." So I did, and she was en route yesterday. So a week after sentencing, the bus was leaving Broward and took her to the reception center. So some of this information is pending, and some of it will be pending for a while until she gets to her assignment. But right now is when they do the physicals, they do all different kinds of assessments to find the best fit for her, because typically they're not moving people around multiple different places over your time in custody. You're there and you're there for life, right? So that's what's going on there. But let me also let you know, there was some interesting things happening on the docket. So um in between the time that she was sentenced last week, her lawyers have already filed for their appeal, if you can believe it. Let's go to the docket. Okay, here we go. Let me make sure you guys can see everything. Okay, so we're here on the docket. And all right. So as you can see, um, this is the case, Sakiyna Thompson, the state of Florida versus Sakiyna Thompson, right? So these are some of the particulars. Obviously, her initial not guilty plea, her disposition on 1014, her sentencing on 12/1, all of those details, right? She has a bill due. There are some case financials. So if anyone out there is supporting her and is going to get that $568 paid by the 4th of January, she has some monies due to the state of Florida. Along with, I did mention a week or so ago that the prosecution attached a lien to her for restitution to the victims fund, and also the Son of Sam law, so that if she ever decided to try to option or sell her story and there were any financial gains that she could potentially make, that they have already filed a lien against her and any monies would be dispersed accordingly. So she would not be able to make any money off of this particular situation. But let's get to the most important thing. There's quite a few things on the docket, and if you would like for me to go through everything one by one, let me know. But let's go ahead and look at the defendant's notice of appeal. The one interesting thing about this is that, which will be wonderful for us, that they could be ordering a full transcript, which would be wonderful, because it seems like Broward outsources their transcription services to a company and it's quite expensive. And now that they have requested, she is requesting an appeal, the appellate will need to have copies of the actual record, and that should be attached to the file. So in the future, we could potentially see a copy of the transcript, which would be wonderful. So that's kind of what I've been waiting for because I contacted the service and it's quite expensive. So we're going to see what's going to happen with this. They filed this already. They filed this on the 4th, which was, when was that? Thursday? The 4th was Thursday. So her lawyers are busy at work. I mean, they are working for her. These the public defenders, I don't know if these would be her public defenders for an actual appeal, but they have filed a notice of appeal. So let's get into it, guys. Let me see, can I make this bigger? Okay. Let's just get into this. So this was filed on the 4th, to the record. Is this with the details? Hereby given the Sakiyna Thompson appellate appeals to the District Court of Appeal, 4th District, State of Florida, final order imposing judgment of conviction rendered on 10/14, final order imposing sentence rendered on 12/1. And in the above styled cause, the defendant was sentenced to life in prison without possibility of parole. The motion for new trial was denied on 10/23. We talked about that. Notice is also given that the defendant is in custody. I hereby certify that the true and correct copy of the foregoing has been furnished in e-service to the state attorney's office, Antonia Johnson. Okay, that's not the one I wanted to look at. Let's see. Okay, here we go. These are the actual items that they feel are appeal worthy, if you will. So this is what they are stating are the items, and we can talk about these definitely. So this is another document that was filed on the 4th, and notice it's no longer Florida against Sakiyna, it's Sakiyna Thompson against the state of Florida because she is appealing, correct? All right. The defendant slash appellant, Sakiyna Thompson, an indigent, sets forth the following judicial acts relative to the above styled cause in which she plans to seek review on appeal. The court's ruling deferring and ultimately denying the defense's motion in limine regarding the related interaction between Ms. Thompson and the state's witness, Janicia Tate. Now, what was the interaction between Ms. Thompson and the state's witness, Janicia Tate? If you recall, the interview with Janicia Tate, which is on my channel, I have an audio where she's talking to one of the detectives. She stated that there was a particular night where she went to a club with KAYLA, but KAYLA stayed outside. She met up with Terry, and basically Terry and KAYLA took off, and Janicia was there to meet another guy friend. She saw KAYLA at the she saw Sakiyna at the bar. She knew it was Sakiyna from her pictures, from her posts. She knew exactly who she was, and she tells that story in her interview with the detective. I don't know that they've had many other interactions. There could have been some potential interactions in Instagram because allegedly it's possible Sakiyna may have reached out to Janicia knowing that that was her best friend. But of course, we don't have the full trial because it was not televised. Okay. So that's one thing. The court's overruling multiple defense objections, 922 to 1014, basically the whole case. Okay. So the case took place roughly about 3 weeks. It took them almost a week to select a jury, and they had almost 2 weeks of actual testimony, evidence, and the jury took roughly about an hour to make a decision, but they're giving the full span of the trial. So they want the whole trial reviewed. Okay. They're putting the whole dates. Okay. The court's denial of multiple Richardson hearings requests upon defense's objection and request for a Richardson hearing on testimony given by Detective Chris Williams and Detective Miguel Suarez. Now, we need to go back to the incident report to see what specifically Chris Williams and Miguel Suarez had to say. And I think we talked about that one day when I read the full incident report. But I don't recall it off the top of my head. Now, Richardson hearings are typically hearings where they are deciding whether they are flushing out evidence that are coming in regarding particular matters that may not have been discussed previously. So they're saying that the judge denied multiple requests for Richardson hearings. Okay, so Richardson hearings come up when there is evidence that they feel like has come out that was not discussed previously, or that there could be discovery violations, and that it could have been purposeful. Maybe it could have been inadvertent, but it is kind of like a timeout, either during pretrial or during a trial where they have to, the either side who has committed the potential offense has an opportunity to explain why this particular evidence was not shared or brought out or not disclosed, whatever the case might be. And the judge will make a decision whether it's admissible or not. So also, let's see. Okay. So it also comes in with like surprise witnesses or just extra information. You notice sometimes during a trial, they will ask a question specifically and say, tell exactly what you know and don't include information from anything else, specifically answer this question, and or tell what you know specifically and not what you heard or what you learned from something else, like specifically your experience, because then it goes into like things like hearsay and things like that. So anyway, they said that there were multiple denials of Richardson hearing requests, and that is another reason why they feel like they deserve that they deserve this trial to be reviewed by the appeals court. Okay. Number 4, court ruling permitting testimony about a CODIS hit received by the BSO crime lab. Now, the CODIS hit is the system where if you've ever been arrested, they've got a DNA sample from you, the buccal swab, blood, fingerprints, maybe not necessarily fingerprints per se, but let's just say human biological matter. So a buccal swab, DNA, blood. Now, the CODIS hit could have come up because of the nail that was, so when they collected samples under KAYLA's nails, because she fought for her life, and also according to Sakiyna, she was cut across her belly. If that's true, we don't know. Um, but she says she was cut. She sustained some injuries in the fight with KAYLA, proceeding to her death. So it's quite possible there could have been blood on the scene from Sakiyna. So when they processed the blood samples, and then later when she was arrested and processed, there was a nail fragment. There were also there obviously were some other matches because there was a CODIS hit. So the court's ruling permitting testimony about the CODIS hit, they feel like should not have been permitted for whatever reason. And this is reason number 4, that the court's ruling permitting testimony about the CODIS hit received by the BSO crime lab, that was problematic for the defense. The court's ruling allowing, this number 5, the court's ruling allowing testimony that police had not been able to get into Ms. Thompson's cell phone, thereby violating Ms. Thompson's Fifth Amendment against self-incrimination. So the fact that maybe they are saying that they couldn't get into her cell phone, so leaving it open, well, she obviously didn't give them the code. She didn't allow them to get her information, and maybe they felt that that was prejudicial, that information was not available. So they were able to obtain her phone, but she did not give the code or did not allow them to access her phone. And until today, and I believe KAYLA's phone as well, they have not been able to sell break those phones and get the data out. At least at time of trial, they had not accessed KAYLA's phone nor Ms. Thompson's phone, but her team feels like the court's ruling allowing testimony that the police had not been able to get into Ms. Thompson's cell phone. Maybe they had a search warrant for her phone, so I don't know that that would. They're saying specifically Fifth Amendment, so against self-incrimination. So maybe that is because that is her right to not um give the code. I guess maybe just them saying that tells the jury that she was not helpful. Maybe I don't know. I don't know what their thought is on that, but I'm assuming they will probably produce a brief that will go into more detail as to why number 5 is problematic. So once we get that brief with a more detailed breakdown, that'll be interesting. The court's ruling permitting irrelevant and prejudicial character evidence during the cross-examination of Miss Thompson regarding drinking while she was pregnant. Well, we know that doesn't look good. So I'm sure that probably was, there could be some jurors who had feelings about that she was knowingly pregnant. And I guess there are Instagram, TikTok posts that show that she was pregnant and that was problematic. All right, let's go to number 7. The court's ruling allowing testimony about prior bad acts that she had been subject to, that she had not been subject of any Williams rulings hearings, specifically an unrelated violent altercation between Miss Thompson and her boyfriend 4 months prior to the date of the incident. The court's ruling allowing testimony about prior bad acts that had not been subject of any Williams rule hearings. So is that goes back to, okay. So she says Williams rule hearings specifically about unrelated violent altercation between Miss Thompson and her boyfriend 4 months prior to the date of the incident. Okay. Court overruling defense's objection to shifting the burden during the state's closing arguments, overruling defense's objections to shifting the burden during the state's closing arguments. And then number 9, denial of the defendant's motion for a new trial in 1023. I mean, look, they've got 9 reasons, and this is now going to become a appellate issue. And I don't know if the state prosecutor will submit a brief in response to any of these matters, if they're obligated to or not. But I think the next step is that maybe they're going to submit a brief. I'll get some more details on that. So next time we get together on this topic, I'll have some more information for you on that, what to expect next. But I do expect a transcript to be filed because they are going to need that to be able to make the assessment of the allegations in the in with the appeal judges regarding these matters at issue in this trial. Anyway, guys, let me know what you think. Number 1, let's just go back, refresh. Girl, number 1, Sakiyna is at the Women's Reception Center. We don't have her picture yet, but it's coming, okay? It's coming. She's at the Florida Reception Center, and this is the reception center right here in Ocala. Baby. She will be evaluated. It's the Florida Women's Reception Center is a unique facility that has multiple missions: reception, inpatient, mental health, short sentence institution, general population. Each of the missions of the inmates assigned are in different quadrants. The design of the Florida Women's Reception Center allows separate focused missions with minimal contact with the inmates from other quadrants. This separation facility, the creation of different environments within the program, characteristics each mission can't, so each mission can be fully fulfilled. So basically, it's my understanding that you do have opportunity for your assessments, and they make the determination where your long-term facility will be. They clearly say that, like, short sentence, it's a short sentence institution, so we already know by that, ma'am Lifer is not going to be there. But at the end of the day, that's where she's at the moment, and I'm sure we will have some updates soon and see her institutional photo. And that's it. That's all on that. Also, if you did not know, her lawyers have applied and have filed notice that they are appealing. If you watched the sentencing, the judge stated that Sakiyna could appeal at any time in the next 30 days, and they did not waste any time. 3 days, they already have filed their notice and they filed the reasons. And I don't know if they're going to put a support brief with that. But there should be some more movement on this docket as it will roll over to the Florida Appeals Court. Very interesting. I don't know. I'm going to be honest with you. I don't know why this woman feels like she deserves a new trial. She admitted to killing KAYLA, and there was really nothing self-defense about showing up at someone's home unannounced at a very odd hour when this lady had just finished working a shift, and I'm sure not expecting someone from New York who she'd been going back and forth with about, not her boyfriend. I don't know that KAYLA even cared about Terry like that. You know what I mean? So really, KAYLA wasn't her adversary, in my opinion. It was Terry, but that's a whole nother story. Anyway, why she thinks she deserves another shot when at the end of the day, you got on a plane, you got in a lift, you trolled someone's apartment complex for hours until they got home, and then you got into a fight with them that caused the person's brutal murder, and left, didn't call for help, stayed in Florida. I think she left not the next day, but the day after. So just keep in mind, just think of this for a second. When Revelto went to KAYLA's house, found her, she was over there at the hotel, probably sitting there watching all the news unfold about what was going on a few miles away that she had everything to do with. And they're asking, if you know anything, if you've seen anything, if you can be helpful, please contact Crime Stoppers, blah, blah, blah. And she gets on a plane and takes off, goes back to New York, and thinks she got away with it because she didn't leave right away. If you listen to the reading of the incident report, we went through all of that. She went home that morning and left 1 to 2 days after. And I thought also another thing that was interesting was that she flew Spirit Airlines, and that's the airline that KAYLA's mother worked for, Spirit. Just a lot of just a lot. Anyway, interesting turn of events. We're going to see how things go. Um, she has a right to appeal. She has a life sentence. So we will see what the appellate court does with that. I know with death penalty cases, they get an automatic appeal. I don't know that she gets an automatic appeal. The appellate court could just deny it. It may not even go anywhere. And even if they listen to it, it doesn't necessarily mean that anything is they're going to either confirm that the judge made all of the right decisions, that they agree with everything, and that there were no violations. Or if there was a violation, it may not necessarily have changed the outcome, any of those things. So we'll see what the outcome is. Anyway, guys, have a wonderful day. If you're new here and you're enjoying kind of this case deep dive and you're interested in knowing more about this case, make sure to hit my playlist and also make sure to subscribe for more updates. And I'll see you next time. Have a great day, guys.